Hello, I'm attorney Jonathan Bletcher. I'm a criminal defense attorney in Miami, Florida, with my practice primarily in the defense of driving under the influence of alcohol and controlled substance cases. Today I want to talk a little bit about how the government, how the state proves a DUI case. You know, DUI is one of the few crimes that is often based on just the opinion of a police officer. It's not always based on scientific evidence or legal evidence. It's often based on the opinion of the arresting officer. There are three ways essentially that the state can prove driving under the influence. One would be if a person has an unlawful blood alcohol level, 0.08 or above. Almost every state in the United States, in fact all states in the United States, have a 0.08 blood alcohol level as the minimum level for a DUI. The other ways would be to determine whether or not someone's under the influence of a controlled substance. Often blood is drawn or urine is drawn from an individual, and that substance is tested, and the result, if there's drugs in it, can be used to prosecute them for DUI. The third final way would be in the case where an individual doesn't submit to a breath test, doesn't submit to a urine test, they refuse, and the government would then try to prove the individual guilty of DUI by what's called impairment. Now, we've all heard about drunk driving, but the crime is not drunk driving. It's driving under the influence to the extent that your normal faculties are impaired. Well, how would a police officer or the state try to prove somebody guilty by impairment? Well, that would be based on the officer's observations of the driving pattern, weaving, making too wide a turn, excessive speed, running stoplights, things of that nature, failing to maintain a single lane of traffic, getting into an automobile accident. In addition to that, an officer and the state would try to prove an individual guilty of DUI by impairment by their performance on physical sobriety tests. These physical sobriety tests, physical sobriety exercises as they're sometimes called, can be used by the courts and by juries to be admitted into evidence to establish an individual's impairment to operate a motor vehicle. Now, what physical sobriety tests have to do with an individual's ability to operate a motor vehicle is beyond me, but we'll talk more about physical sobriety tests in another video. For more information about these and other topics, please visit our website, DUILawDefense.com. I'm attorney Jonathan Bletcher.